welcome to Policy Exchange. My name is Dean Gonston. I have the pleasure of being your host today for this important keynote, which is one of the most significant interventions in the immigration debate this year. We're delighted to be able to welcome Chris Philp, Present Shadow Home Secretary, obviously with previous experience at the Home Office, the Department of Justice, amongst other government ministries, for his important contribution and experience on the radical overhaul of the immigration legal system, which he's been advocating for some time. This is the fleshing out and outworking of all of that. And as I say, no usual house rules, no question too outrageous. You just have to state your name and organisation first. Also, like particularly to extend the warmest of welcomes to the person who's the victor ludorum for the longest distance travelled, Alexander Downer, Chairman of Trustees of Policy Exchange, longest serving Foreign Minister in Australia's history, played so important a part in the Commonwealth of Australia's policies on their immigration crisis, and also played a significant part in the lifetime of the last government for his part of review on our own procedures, and still a very important voice in these matters. So Chris, always welcome here. Look forward to hearing what you have to say, and no doubt there'll be many contributions both here in person and online as well. Thank you. Join our guest of honour today.
Well, Dean, thank you very much indeed for that very warm welcome. A huge pleasure, as always, to be here at Policy Exchange, and honoured to be here with Alexander, who, of course, has an distinguished record down under in Australia, where, of course, the government, back in about 2013, very successfully undertook a task rather similar to the task we have to undertake in the future. Dean, thank you also for the work Policy Exchange have done in this area, including your Judicial Power project. Thank you for that, and please keep up the good work. Now, let me start with the very sad story of Rhiannon White. Rhiannon was just 27 years old and worked in an asylum hotel. On the evening of 20th of October 2024, Rhiannon had finished her shift and walked to a nearby station to get the train home. She was followed by Deng Majek, an illegal small boat immigrant from Sudan who had entered the United Kingdom 3 months earlier. He attacked Rhiannon, stabbing her 23 times and tragically killing her. I've met Rhiannon's mum, Siobhan, and she has said this to me: "It's not fair that an illegal immigrant could come into the country and do this to my daughter. Why doesn't the government stand up and do something?" Well, I think that's a very good question. Cases like Rhiannon's are why public trust in the government on immigration is so low. The government has not stopped mass channel migration. Over 73,000 have crossed since the election, more than under any other Prime Minister. Every time a new rape or assault by an illegal immigrant is reported, public trust goes down further. Such as 3 small boat migrants gang raping a woman on Brighton Beach, a 12-year-old girl in Nuneaton raped by an Afghan illegal immigrant, a woman in Hyde Park raped by an Egyptian illegal immigrant who was also a convicted Islamist terrorist, a 14-year-old girl in Epping sexually assaulted by an Ethiopian illegal immigrant, and of course Stephen Ogilvie in Belfast, almost beheaded last week in broad daylight by a Sudanese illegal immigrant. The list goes on and on. And the public is equally unhappy that likely well over 1 million people are in this country illegally. The problem extends to foreign criminals. While foreign criminals are deported in quite large numbers to European countries like Albania, Poland and Romania, relatively few non-European criminals are deported. Last year, for example, only 110 foreign criminals were deported to Jamaica, Iraq, Nigeria and Somalia put together, despite there being over 10 times as many prisoners from those nationalities in prison and many more out in the community. In fact, there are now 20,000 serious foreign criminals who have been sentenced to over a year in prison, but who are now circulating on our streets after release. Every single one of those is a risk to the public. The consequences can be fatal. Convicted criminal Ernesto Elliott was due to be deported back to Jamaica, but he was removed from the flight following a human rights claim. A few months later, Elliott murdered 35-year-old Nathaniel Awu Agu in southeast London. If that deportation had gone ahead, then Mr. Awu Agu would still be alive today. And even when an asylum claim fails, other legal challenges often prevent removal. So last year, only 12,000 failed asylum seekers left the UK, even though 80,000 applications were rejected that year. The failure to grip immigration is undermining trust in democracy itself. People vote for illegal immigration to be ended. They vote for foreign criminals to be deported. And yet it doesn't happen. This situation is completely unacceptable and it must change. Mainstream political parties must now have the courage to take the radical steps needed to fix this, or the public will turn away from the mainstream. We must start by asking why this issue has not been fixed. The truth is this: politicians are not properly in control of the immigration system. The courts are. The lack of parliamentary and ministerial control of the immigration system is undemocratic. Radical and sweeping change is needed to end the tyranny of the courts and restore democratic control over immigration. Because over the years, Parliament has allowed the creation of a legal system that hands near unlimited power to judges to decide individual immigration cases and the power to shape how the whole system operates through case law. And judges have used that power over time to make the system more and more permissive. So illegal immigrants and foreign criminals often cannot be deported. The consequence is that the UK becomes an attractive destination for illegal immigrants. I want to examine exactly how this has happened. First is the ECHR. Lord David Wolfson KC has brilliantly exposed how the ECHR, implemented domestically by the Human Rights Act, prevents effective border control. The way judges in the UK have interpreted the vaguely worded ECHR clauses is often more expansive than their European cousins or even the judges in Strasbourg itself. That is possible because the ECHR articles are necessarily very broadly drafted. For example, Article 3, which says freedom from torture, inhuman and degrading treatment. Now, that was originally written to mean don't send people to concentration camps. And nobody would argue with the clause as it's drafted, or would argue with it if it was reasonably interpreted. But the problem is it's now interpreted in a way that is unreasonable. Judges now say that inhuman treatment includes sending an Iraqi drug dealer back to Iraq because apparently he had become, quotes, too westernised. It is now also considered to be inhuman treatment to send a convicted paedophile back to Zimbabwe because as a paedophile he might face hostility in Zimbabwe. The court gave no thought whatsoever about the rights of British children to be protected from that paedophile or the right of the democratically elected parliament to decide who stays in this country. So these criminals were allowed to stay in the UK. In my view, that is totally unacceptable and it has to end. And because the ECHR sits above national law and is given full domestic force, including in our courts, by the Human Rights Act, there is very little Parliament can do about its effects. Even where Parliament legislates, individual decisions then risk getting injuncted by the court if the court considers them to be ECHR incompatible. It has anyway been the policy, in my view wrongly, of successive governments to almost always legislate in a way that is compliant with the court's expansive interpretation of the ECHR. And I remember vividly, as a minister a few years ago, designing what is now the Nationality and Borders Act. I wanted to raise the asylum threshold to make it harder to get asylum, so only people who could clearly prove they were at risk of being persecuted would get asylum, which is not how the system works at the moment. But I was advised, and I got external legal advice, I didn't believe it when I first heard it, I was advised that while I could change our domestic asylum law, there was no point in doing so, because migrants would simply make the same claim under ECHR Article 3, and the judges would grant the claim by applying a similar criteria to current asylum policy. So, as an elected minister, in a government with quite a big majority, I couldn't legislate through Parliament to have the effect I wanted, even if I could get Parliament to vote for my legislation, because of the way the ECHR operated. Then we come to modern slavery. Tony Blair signed up to the ECAT Treaty in 2007, and the 2015 legislation which followed it is all very well-meaning. It's designed to stop people being abused. But it's so generous that it allows foreign citizens with what they call reasonable grounds to say they're modern slavery victims to avoid or delay deportation. The threshold for establishing that claim is extremely low. A plausible sounding claim with no evidence whatsoever gets accepted. And as a result, tens of thousands of people, illegal immigrants and foreign criminals, have successfully used modern slavery claims to prevent or substantially delay deportation. And then we come on to asylum claims. Almost all small boat illegal immigrants claim asylum, and from countries like Sudan, Eritrea, Syria and Afghanistan, almost all applicants eventually get asylum. So no wonder so many people from those nationalities leave France, a safe country, and illegally enter the UK. The evidence needed to establish an asylum claim is laughably low. Some people claim to be Christian, often purporting to convert after arriving in the UK, and very often that is signed off by a well-meaning but misguided vicar. Many applicants claim to be gay, or if they inconveniently have a wife or child, or in one case have been convicted of raping a woman, they claim instead to be bisexual. Some, claiming to be dissidents in their home country, only joined an opposition group in their home country after arriving in the UK to help their asylum claim, advised, of course, by their immigration lawyer. But this nonsense has all been accepted by the courts. Many of these human rights, modern slavery and asylum claims are made in very similar forms, often only being made after advice from an immigration lawyer has been received. All of that is funded by immigration legal aid, with funding lawyers who sometimes advise illegal immigrants to fabricate plausible sounding but made up claims, which was recently exposed by the BBC to their credit, who secretly recorded the associate of an immigration lawyer advising illegal immigrants to fabricate claims to be gay or domestic abuse victims in order to stay in the UK. And they did that because they knew the legal system would simply accept it. It gets worse. You can make multiple claims over time, so the whole circus can be dragged out for years and years and years. I recall the notorious case of Yaqub Ahmed. This man was a Somali illegal immigrant who violently gang-raped a teenage girl. After his prison sentence, the Home Office, quite rightly, tried to deport him back to Somalia. But over many years, Mr. Ahmed made multiple asylum claims, human rights claims and modern slavery claims before finally being deported in 2023. But it took 8 years to deport a man who had gang-raped a teenage girl. And there's always judicial review as a last resort for the courts to stop someone being deported or to challenge a government policy. Then we come to the immigration tribunal itself. After the Home Office has made a decision, it can be appealed to the first-tier tribunal. Now, the waiting time for an appeal is now over a year, and there are 150,000 cases before the tribunal. And if the immigrant doesn't like that decision, they can appeal again to the upper-tier tribunal instead, which takes another year. And if that claim gets dismissed, they can just make another one and start the whole process again. Some of the judges who make decisions on the tribunal are themselves extremely suspect. A number have previously been or supported open borders campaigners. Immigration tribunal judges have previously worked for open borders groups like Asylum Aid, Refugee and Migrant Justice, Refugee Action and Safe Passage UK. Needless to say, those organisations have no interest in border control whatsoever, as their names imply. Given the evident biases of some tribunal judges, it's no surprise they've made some extraordinary decisions. For example, Judge Hugo Norton-Taylor handed down a judgment using ECHR Article 8 to allow Palestinians to enter the UK to join family members here, despite the government expressly having decided to create no such route. A Ghanaian criminal, deported 12 years ago, was allowed back into the UK, again using the ECHR, claiming he felt depressed back in Ghana. a Nigerian armed robber who a criminal judge found presents, and I quote, a high risk of serious harm to the public, won an appeal against deportation back to Nigeria because apparently the mental health system in Nigeria is not as good as in the UK. Another immigration judge allowed an Albanian burglar with 50 convictions, 50, so he probably committed more like 500 offences, given how low the conviction rate is, but 50 convictions, to stay in the UK because apparently that offending was, quotes, not very extreme. So if your house gets broken into by an Albanian burglar, you know which judge you can thank for that. These cases show immigration tribunal judges handing down decisions that fly in the face of common sense, but they are enabled by the current system. This is an insult to the British public, and it has to end. Given the thicket of opportunities to prevent deportation, it is perhaps no surprise that 93% of small boat illegal immigrants get to stay here, so no wonder they cross in the first place. And the numbers of foreign criminals deported to countries outside Europe is so small. So what is the solution? I've come to the conclusion, having studied this for quite a few years now, that only radical action, really radical action, will return control over the immigration system to Parliament and take control away from the courts. First, we need to leave the ECHR and repeal the Human Rights Act in its entirety. Now, in doing this, we should not replace those instruments with a domestic version, because a British Human Rights Convention or British Bill of Rights would necessarily be vaguely worded, just like the ECHR, and so the same problems of expansive and unreasonable judicial interpretation would arise. And Policy Exchange has written some excellent research making exactly that point. Now, most important and reasonable human rights are already in domestic law or common law, but if Parliament feels there is a gap in domestic rights, of course, Parliament can legislate to fill the gap, but it should do it in precise and detailed terms so that we can't have this problem with open-ended and unreasonable judicial interpretation. Now, the Labour government says they're going to tinker with the definition of Article 8. That's their solution, but that will make no real difference whatsoever. It was tried in the past, I think by Theresa May, and it didn't really survive contact with the courts. They also point to discussions at the Council of Europe about reforming the ECHR as a whole, but that will require 46 member states to unanimously agree, and it will also require the Strasbourg court, which is stuffed full of human rights aficionados, to agree, and in my view, there is no chance of that happening at all. In fact, in supporting that argument, Lord Hermer himself, the Attorney General, actually admitted as much last September to the Lords Constitutional Committee when he said reforming, changing the ECHR was simply, quotes, a political trick. That is literally the only thing Lord Hermer has ever said that I agree with, but on that point he was actually right. Now, human rights advocates like Keir Starmer claim that leaving the ECHR would mean we can't cooperate with other countries on migrant returns and other issues. Now, that is clearly nonsense. Most countries we need to return illegal immigrants and criminals to are outside Europe and aren't even in the ECHR themselves, and plenty of European countries who are ECHR members quite happily cooperate with the USA, Canada, Australia, New Zealand, and many other countries, none of whom are in the ECHR, and all of whom are perfectly respectable. So the government's argument about international cooperation is clearly nonsense. Secondly, we need to radically reform the asylum system. Illegal immigrants, like the Sudanese man who committed the Belfast attack last week, should simply not be able to claim asylum at all, period. No asylum for illegal immigrants. Illegal immigrants should instead be rapidly deported. And where we do allow an asylum claim, the bar for accepting it should be high, with real evidence of a genuine risk of personal persecution, by which I mean things like threat to life, imprisonment or torture. I do not mean day-to-day inconvenience, a less generous welfare or health system, or requirements for military service. None of those things, in my view, amount to persecution. Now, we can implement that change by amending domestic legislation, and outside of the ECHR and without the Human Rights Act, there is nothing the courts could do to override that as they do today. Thirdly, of course, we need to end the right basis of modern slavery claims to allow people to stay in the UK. That will mean leaving the ECAT Treaty and changing the Modern Slavery Act and other bits of domestic legislation. A modern slavery claim should not prevent an illegal immigrant or foreign criminal from leaving. Fourthly, we will completely abolish the Immigration Tribunal and completely abolish immigration legal aid. Immigration decisions should be made by the Home Office with a quick internal appeals process. Applicants should simply present the facts of their case. A decision will be made. The assistance of external lawyers who have been known to coach the applicant to lie, as the BBC recently exposed, will no longer be required. And finally, judicial review of immigration decisions and policy should be severely curtailed. Judicial review on the grounds of irrationality, sometimes called Wednesbury unreasonableness, procedural impropriety, which often means things like not consulting properly, allegedly, or the supposed legitimate expectations of the illegal immigrant should all be excluded or ousted as grounds for judicial review. But I do accept we need a guardrail of some kind. So as a safeguard, judicial review of immigration decisions would be allowed only on the narrow grounds of vires. That is to say, the government is acting outside its statutory powers. For example, the government should obviously not be able to apply immigration powers to British citizens or those with the lawful right to be here. And I accept the court should be able to step in and prevent that if it was attempted. Now, I estimate the measures I've just set out will remove about 98% of current immigration cases from the court system. So it'll essentially remove the courts from immigration matters, apart from those 2% of cases which would be judicial review on the grounds of vires. Now, as a further safeguard, in exceptional humanitarian cases, I do think the Home Secretary should have the discretionary ability to allow someone to enter or to stay, but the use of that power should be discretionary and should not be open to judicial review. Of course, at times of international crisis, it would be open to Parliament to create a bespoke humanitarian entry route on a case-by-case basis. And in fact, this has actually happened 4 times in the last 10 years for Hong Kong, Ukraine, Syria, and Afghanistan. So, ladies and gentlemen, this set of proposals represents a complete departure from the approach to immigration law that has grown up over the last 40 years. It's a radical overhaul, completely changes it. But that is necessary because the system is so clearly broken. The public has lost trust. Elected politicians are being systematically prevented from controlling our borders. The truth is we have lost control, and half measures or tinkering will not get it back. These sweeping reforms will end control over immigration by the judiciary. It will return control to Parliament. It will enable democratically elected ministers to decide who can come to the UK and who can stay. The public will once again be able to decide through elections how the UK immigration system operates. And if the choice were mine, if I were Home Secretary, I would use these freedoms to deport every illegal immigrant, people like Deng Majek, who murdered Rhiannon, within a week of arrival to their home country if possible, and a third safe country if not. That would rapidly deter anyone from entering the UK illegally, including by small boat. I would also use these powers to ensure the deportation of all foreign criminals, not just some. I would ensure that over time, all those here illegally would be removed. At the moment, doing these things is virtually legally impossible, which is why successive governments of both colours have not done them. These sweeping reforms are critical to restore trust in politics, they restore parliamentary control, and they end the tyranny of the courts. It is now critical that mainstream politicians have the courage to make these radical changes, because if we don't, the public will turn away from the mainstream. The public rightly expects our borders to be controlled, and this plan will deliver it. Thank you. And now I'm very happy to take questions on this or indeed any topic. I'm told by our hostess this afternoon there is a cast iron policy exchange rule, which is that you can ask whatever you like, no matter how outrageous or offensive, but you've got to give your name and, if applicable, your organisation before asking the question. There is no anonymity in this room, but you've got the freedom to ask whatever you like. Now, I can see there's a question online from Dave Barrett, who is the Home Affairs correspondent at the Daily Mail. How does that work? Do you read it out, or does Dave suddenly pop up on the loudspeaker?
You should be able to hear me now, I believe.
We can hear you.
Mr. Philp, obviously you've outlined major reforms to ECHR with a complete ditching of it and not repeating the previous Conservative government's policy of including it in any future Bill of Rights. Could you guide us on whether a future Conservative government would leave ECHR on day one of a new administration, or would there be some timescale involved in order to bring that into effect, please?
Thank you, Dave. Nice to hear from you, as always. So the mechanism for exiting the ECHR is to give 6 months notice, and I would expect to do that pretty much straight away. That 6-month period would then provide an opportunity to legislate or to prepare domestic legislation to take advantage of exit. That would most obviously include repealing the Human Rights Act, but it would also enable changing a whole load of domestic legislation around, for example, asylum law, the law around deporting foreign criminals, currently in sections 32 and 33 of the Borders Act 2007. But because we are taking this very seriously, we've developed a credible plan, as you've heard. We're going to do that preparatory work in opposition, so we are ready on day one. And that stands in contrast to the woeful lack of preparation we saw from the Labour government when it was elected 2 years ago, and also the lack of plan, the lack of serious, credible plan we see from Reform as well. Thank you, Dave. Matt Dathan from The Times.
Thank you.
Hello.
Can you hear me? Yep. You've already introduced me, Matt Dathan from The Times. By politicising the whole asylum appeals process, by basically putting politicians in charge rather than judges, don't you actually risk, if there was in theory, a future very left-wing government or a Green Party government or even an Andy Burnham government, let's say, don't you risk actually more asylum seekers getting granted if you are putting politicians who are in favour of what you would call open borders?
Well, first of all, I find it hard to believe the situation could possibly get any worse than it currently is. I mean, those cases that I referred to earlier, a Zimbabwean paedophile not getting deported because he would face hostility back in Zimbabwe is obviously absurd. Someone who's raped a woman claiming asylum successfully because he claims he's bisexual is ridiculous. An Iraqi drug dealer not getting sent back to Iraq because he claims to be westernised is ridiculous. I can't imagine how this system could possibly get any worse, frankly, than it has done under the supervision of the courts. That is the first point. Secondly, it is about restoring democratic control. Now, I believe in democracy. The case I've made is we need extremely tough border measures. Every single illegal immigrant deported within a week of arrival, and no asylum claims by illegal immigrants at all. And then I just noticed that I think Siobhan White has just joined us. She's the mother of Rhiannon, who I talked about at the beginning. If Deng Majek had been deported within a week instead of put up in an asylum hotel, then Rhiannon would still be alive today. But I think those decisions should be made by the public democratically. That's the approach I'd take. But it would be up to the public to decide which politicians they elect. I don't think the public would elect politicians that open our borders. I think the argument I've made would win. But in democracy, it is up to the people to decide. It should not be up to unelected judges, and that is what is currently happening.
Keith, can you hear me? Yep. Keith Bears, GB News. Net migration hit a record 906,000 under the Conservatives. Why should voters trust your party on immigration when the highest figures on record happened under your watch? How will you convince some in your own party to support your measures, such as leaving the ECHR? And finally, you say it's important politicians now have the courage to act. Why didn't you before? OK, so first of all, I obviously wasn't the Prime Minister and I wasn't the Home Secretary in the last government. And the immigration figures you mentioned from 2 or 3 years ago, frankly, should never have been allowed to happen. That was a terrible mistake and it shouldn't have happened. Now, reforms were made late in the time of the last government. They were introduced in April 2023 and April 2024, which have dramatically reduced net immigration. When Keir Starmer and Shabana Mahmood says net immigration has fallen under Labour, that is grossly misleading because it's as a result of changes made by the last government, made too late, but nonetheless made by the last government, which have now been taking effect. In fact, the main change implemented so far by the Labour government has been to weaken those changes by not increasing the family visa threshold to 38,000 as we had planned. But so that's on legal migration. To be honest, it still hasn't gone far enough. The net figure recently was 200,000 in. But if you
split that by European, UK and non-European, that was still net non-European migration of 400,000. And in fact, it was 600,000 coming in. And in my view, 600,000 people coming into the UK from outside Europe is still unacceptably too high. We should have zero low-skill migration, in my view. You asked why people should trust us now. Well, we are under new leadership. Kemi is our new leader. I'm the new Shadow Home Secretary. And we've set out in detail how we'll do this. Right, the speech I've just given isn't vague. It's not full of platitudes or wishes. It is detailed and it is specific. And we're the only party that has plans that are that detailed. Reform, for example, doesn't. Sure, they've got good rhetoric, and we've seen Zia swaggering around Brighton Beach in his sunglasses, but they don't have a detailed, credible plan like this one. Why wasn't it done before? Well, you'd have to ask the people who were in charge at the time. But I've reached the conclusion that these radical changes are the only way we can get control of our borders, and that's why we set these plans out, and I've given the speech with this detail in it today. Yes.
Damien Grammaticus from BBC. You just said ask the people who were in charge at the time why something wasn't done. You just mentioned the case of Yaqub Ahmed from Somalia. You were asked in the Commons, I think it was 2023, about that case, and you said you would do something about it within a year, and you didn't. But more importantly than that, I was at the Conservative conference last year. I think everything you've just mentioned was mentioned then. It's been mentioned for over a year. What's new in your speech? Why are you giving this today?
Well, in 2023, I was not Immigration Minister, but he was actually deported, finally, in 2023. And that case, Yaqub Ahmed, is exactly why we need to change the system. It was despite the fact the Home Office, for 8 years, really tried hard to deport this man. The Home Office was regularly in touch with the young girl he had raped, who was by then, I think, in her 20s or 30s. And she was distraught by the fact this guy wasn't being deported. The Home Office tried really hard, but because of the legal system, it took 8 years. And that's what led me to the conclusion that the only way of fixing this is this very radical and fundamental set of reforms. I don't think I forgot to answer Keith's last question, which was the sort of Conservative Party unanimity. Now, when we announced ECHR withdrawal at conference last year, not a single Conservative MP opposed the plans that we set out on the ECHR, which I think is a measure of how much the party has changed, but it's also a measure of how united we are around these plans. And what I've done today, obviously some of these items like ECHR withdrawal we've announced previously, but this has set out in more detail, practically, how we would reform each of these areas and how we would then use those powers to get control of our borders, particularly in relation to illegal immigration and foreign criminals. There's clearly other work that needs to happen on legal migration, but this represents like a very radical change from the way the system currently operates.
Sorry. Can I just clarify, though? The question was that these are all things, exactly what you've said now, is exactly what you announced last year. So what is actually different?
Well, I've been filling out the details around each of them because we didn't have time to do that at conference because there was a lot else going on. And secondly, I've framed this in terms of essentially sovereignty or control, which is to say I've made the case today that democratic control, parliamentary control over the immigration system has been lost. We've got what I've termed the tyranny of the judiciary, which is not a phrase we've used before, needs to be ended. So the additional detail and that framing is what is new here today. Restoring democratic control and ending the tyranny of the judiciary. Yes.
Will Dunn from the New Statesman. Have you costed your plan to remove all illegal migrants within a week of arrival? If so, how much is that going to cost? And do your costings include things like payments to other countries with whom we don't currently have a deal, such as Afghanistan?
So first of all, on costings, we would double the budget for what is currently called immigration enforcement. It's currently about £800 million a year, and we would double that to £1.6 billion, which would help support the immediate deportation of illegal immigrants and, in fact, working through the 20,000 serious foreign criminals who are still here out on the streets after release from prison. That should be zero, and working through the people who are here illegally. So, yes, doubling the budget. But, of course, by deporting illegal immigrants within a week of arrival, very quickly people would stop crossing the channel in the first place. If you're an illegal immigrant in France and you know if you're going to come to the UK, within a week you're going to get deported, back to your country of origin or a safe third country like Rwanda, you're not going to bother making the crossing. And we've seen that work elsewhere. In fact, we've got the former Foreign Minister of Australia with us, and back in 2013, exactly that approach worked in Australia. They called it Operation Sovereign Borders. So by doing that, we'd pretty quickly save the £4 billion a year cost of the asylum system. I'm not sure, Alexander, if you want to say a word or two just about how that works in Australia.
Well, I think you've described it. Do you want
to take the microphone?
In the case of Australia, we had an offshore processing centre in an island called Nauru. So they were immediately transferred to Nauru, people who arrived illegally. And then we would endeavour to deport them back to their countries of origin. Yeah. Otherwise, they would have to stay in Nauru. And
I was talking to the former Prime Minister of Australia, Tony Abbott, last autumn, and he said that after that was implemented, in I think it was September 2013, within a matter of months, like 3 or 4 months, the number of illegal maritime arrivals, as you called them, from Indonesia towards Australia went from tens of thousands a year, so similar to our numbers, down to 0 within a matter of a few months. Am I correctly informed?
Exactly correct, because it's not worth their while, the asylum seekers paying a people smuggler to come to Australia and then find themselves not able to stay in Australia, so they simply wouldn't pay the money. So we have, well, I wouldn't say no problems, but we have virtually no problems with people coming into the country illegally through that method.
So the model I've described is based on the Australian one. It is, of course, better to deport them directly to their country of origin, and that comes to the second part of your question. So I believe any country, anywhere in the world, should receive back its own citizens if they've committed a criminal offence or if they're illegally in another country. We as the UK do that. If a British citizen, if you or I were in another country illegally, the UK would take us back. If you or I were in another country and committed a crime, the UK would take us back. I would expect every country around the world to do the same. If they don't, then there are measures we would take to compel them, such as visa sanctions, meaning we would essentially, at the most extreme level, stop issuing new visas to people in that country to come into the UK, because why should we accept people to come to the UK if we can't deport them if they're then here illegally or they commit a crime? And we would also use the overseas aid budget, so essentially withhold overseas aid funding from countries not taking back their own citizens, because I think it's completely unreasonable. If for any reason we couldn't remove a particular person to their home country, their country of origin, then we'd look to have a safe third country like Rwanda. But the intention would be to deport the vast majority of people back to their country of origin. And as Alexander just said, within a matter of a few months, the deterrent effect would kick in and people wouldn't bother making the crossing from France in the first place if they knew they were going to wind up back in their country of origin. Yes, at the back. Oh, I meant the lady, but you go first, that's fine.
Hi, thank you. Mathilde Hortique from PA Media. You speak about taking power away from the judges and back into the Home Office. The Home Office has its own really high backlog of initial asylum claims. I think 49,000 cases at the end of 2025. How can you trust an already cracking system to take on more pressure? And how can you guarantee that that won't add even more delays and even more backlogs when initial asylum claims are taking 6 months to a year to get heard themselves?
Yeah, well, I mean, first of all, in addition to the asylum caseload in the Home Office, there are 150,000 cases now before the first-tier tribunal, which take not 6 months but a year, so we'd get rid of all of that completely. Secondly, the deterrent effect, we just discussed a second ago, means there will be fewer asylum applications in the first place. And then thirdly, all of those 150,000 appeals that have gone to the Immigration Tribunal, which we're going to abolish, involves a lot of caseworking. Right, probably over half of the Home Office staff in this area are working on processing those appeals. And if you've got rid of the Immigration Tribunal, so there are no appeals, those staff could be transferred to working on first case asylum claims. And fourthly, we're saying we're going to completely ban asylum claims by illegal immigrants. Like last year, 41,000 people crossed the Channel illegally, and pretty much all of them, like well over 90% of them, getting close to 99% of them claimed asylum. Right, under my proposals I just went through, that would be 0. They wouldn't be claiming asylum at all. They'd be getting deported, so there'd be no decision to make. So very rapidly, the asylum caseload would drop like a stone for those 3 or 4 different reasons. Yes, sir.
Hi, Brian Simpson, Belgrave Capital Management. Given that there's a reasonable chance, at least in my opinion, that the next government could be a coalition between you and Reform, how aligned are the policies that you've put forward today with those of the Reform Party? And if they're not, operationally, how would you sit down and go over them round the table to allow them to be put into practice if you both got into government together?
Well, I think as Kemi has very clearly said in recent days, we are fighting to win a majority at the next election, and we have no plans to go into coalition with anybody. And look, I think the plans we have here, these are part of the plans, but by no means all of them, are clear, they're detailed, they're credible, they are properly thought out, they're rooted in a proper analysis of where the problems are at the moment. And Reform, I'm afraid to say, have nothing like this. They don't have the detail and the credibility, part of which that I've just gone through. So, no, we're not planning any coalitions. We're planning to win the election and implement the plans that I just set out. Okay. Do we have... Yes, sir.
Hello, David Goodhart from Policy Exchange. Have you considered the fact that at the moment in quite large parts of the eastern border of the European Union, ECHR rulings are just being routinely ignored now? Have you considered the possibility of just ignoring the immigration aspects of the ECHR and doing it, in alliance with other countries that would like to do similar things, like Sweden, Denmark, Austria, Italy, maybe? What sort of contact do you have with maybe supportive political parties in those countries? And would not that be a way of freeing yourselves from the ECHR restrictions on immigration without all the complications of the Good Friday Agreement and so on that people complain about?
Legally, you're right to say we could repeal the Human Rights Act, which gives the ECHR domestic force, and then simply ignore judgments in the Strasbourg court. I think there are a couple of problems with that. The first is judges here would still probably try and interpret our laws in a way that was in some way compatible with our international treaty obligations. They often judges, even where a treaty hasn't been incorporated, sometimes it kind of shades in a sort of subtle way into domestic judgments. And secondly, I think it's quite dishonest to say we're going to sign an international treaty and then with a court attached to it, the Strasbourg court, and then flagrantly ignore its judgments. We do generally want to abide by our international treaty obligations. And so I think the most legally watertight, firstly, and secondly, the most honest way of approaching this is just to pull out entirely. I don't accept the various counter-arguments. I don't accept it makes us an international pariah. Australia is not in the ECHR. They're not an international pariah. I don't accept the argument that it'll mess up the Good Friday Agreement. David Wolfson, in his analysis, I think demonstrated that the Good Friday Agreement is not the obligations do not require full ECHR membership. His analysis set that out very clearly. And I don't accept the argument that absent the ECHR, somehow the UK will be some kind of lawless territory where human rights are disregarded. We have had very strong rights in this country prior to the 1998 Human Rights Act and prior to signing the convention in, 1950. So I think the most honest and the most legally effective way to do this is just to come out. I have had some discussions with politicians in other European countries, and this was probably a few months ago, I didn't detect a huge willingness there for them to either disregard judgments, this is more countries like Germany, to disregard judgments or pull out entirely. I don't have confidence in the supposed reform process, so I think the only way to make sure we can fix this problem urgently is just to come out completely. I can see as a lawyer called James Kellick is online and wanting to ask a question. James, over to you.
Hi, thank you very much for your presentation. You've obviously been critical of the British judiciary, and I wondered if you felt that reform of the judiciary was necessary, and if so, what reforms you would implement.
Well, I'm not sure if you heard everything I said earlier, but when it comes to the Immigration Tribunal, I think it's beyond reform. It should just be abolished completely in its entirety. And when it comes to judicial review of immigration matters, that should be severely restricted to being on vires grounds, statutory power grounds only. So I think taking the judiciary almost entirely out of immigration cases is the only real way to fix this, because so many judgments over time in the Immigration Tribunal or judicial review before the High Court have led to what are, in my view, manifestly unreasonable judgments, which is why I've proposed the very radical set of reforms that I have here. Matt, second bite. Matt Dathan from The Times. Yeah, go on.
Unless anyone else has questions. You've obviously served in the Home Office under several roles, so you'll know whether there's quite a lot of resistance to these plans, or there would be. They're quite controversial, quite contentious. Do you think there is quite a lot of resistance in the Home Office and the wider government to implementing these plans, leaving the ECHR, ripping up the asylum appeal system? And how would you go about overcoming that? Because Reform have effectively said they would just sack people and appoint people who do agree with their plans.
Well, look, my expectation would be that civil servants are appointed to serve the elected government, and I would expect them to do that. Clearly, without all of these legal mechanisms like the ECHR, modern slavery claims, judicial review and so on, the options for anyone to frustrate these changes is very limited. I would expect civil servants to implement laws passed by Parliament and instructions given by democratically elected ministers. It's as simple as that. Yes.
Hi, Madeleine Sumption from the Migration Observatory. Am I right in thinking that one of the key differences between your policy and Reform's policy is that Reform have effectively said they don't support the principle of non-refoulement, so they would be happy to send people back to their countries of origin regardless of the treatment that they would face there, whereas your policy is that that if someone is recognised as a refugee, even if you want to narrow the definition of who counts as a refugee, then and even if they've arrived illegally, you wouldn't send them back to their home countries. For those people, you would need to look at a safe third country, or is that not?
So for people who enter the country illegally, for example, by small boat, or the Sudanese man who entered Northern Ireland illegally from the Republic and committed that terrible crime last week, they would not be able to claim asylum at all. There would be no asylum claim. So the concept of non-refoulement wouldn't apply in those cases. We would generally look to return to their country of origin if a determination was made they were genuinely at acute risk in that country of origin, which I think is rarely the case, to be quite honest. Most of these people coming across the Channel are not genuine refugees in the sense they're fleeing political persecution. They're mostly young men who are essentially economic migrants seeking a better life, right? They're doing that. The vast majority, I don't think, would meet that category. But in the very small number of cases that did, there would be a power for the Home Secretary to send to a safe third country like Rwanda. But I would expect the vast majority of cases of illegal immigrants to entail return to their country of origin.
And can I just, how would you know then, if there's no asylum claim, there would have to be presumably some kind of asylum light system within the Home Office in order to know whether there was in fact that risk?
Well, there is already a questionnaire when people enter, and the question would get asked and a very quick determination made, but it wouldn't be a full-blown asylum claim, and it certainly wouldn't be reviewable by any tribunal or by the courts. And as I say, very quickly, the deterrent effect of that would mean illegal immigrants stop entering the country in the first place, because they know they're 99% likely to get deported. They wouldn't bother entering to start with, exactly as Australia found back in 2013. Okay, have I exhausted the audience with questions? I think we're almost exactly at 1 o'clock. Oh no, someone on the screen. Okay, Holly Bancroft from the Independent. Holly, the floor is yours.
Hello, thanks for this. I just wanted to ask how you would stop more people coming to the UK on legal short-term visas like student visas, worker visas from going on to claim asylum instead. And also on detention capacity, are you looking to rapidly increase the amount, and also would people stay in detention indefinitely until they can be removed? And who would make the decision on whether they can leave detention? Thank you.
So on the first question about legal migration, I mean, this speech obviously is principally about illegal migration, but we would also hugely tighten up legal entry routes. I think far too many people are being allowed in to work in what are clearly not skilled jobs. We saw that reporting recently of people getting, kebab shops being visa sponsors. That is clearly ridiculous. Working in a kebab shop is not a high-skilled job. We would have much lower caps on inward migration, legal migration across all different routes, with much higher skill and salary thresholds. In my view, there should be zero low-skilled migration. There shouldn't be any low-skilled migration at all, just a limited number of high-skilled migrants. And we would just significantly tighten up the visa processing system, so countries, it would become harder, even harder, to get a visa to come here from countries with large numbers of asylum claims. You asked a question about immigration detention, so I've already answered a question about, from the New Statesman about cost. We would double the immigration enforcement budget from 800 million to 1.6 billion, and that would include increasing detention capacity. But I would expect deportation to happen very quickly, particularly for illegal immigrants who come here on small boats, because if there's no asylum claim, there's no appeal to the court, there's no judicial review, that will happen within a week, right? Happen very fast. So you'll get very high turnover through immigration detention. At the moment, I think from memory, these are approximate numbers, there are about 9,000 enforced deportations per year, which in my view is far too low. There are about 3,000 or 4,000 immigration removal centre places. So that implies the average immigration removal centre place only leads to something like 2.5 to 3 deportations per year, one every 4 months, which is ridiculous. People who enter the country illegally should be getting deported within a week, pretty much illegally. So the immigration detention estate will get used a lot more efficiently than it is at the moment. Because at the moment there are endless legal claims, which mean people stay there for weeks or months on end, and quite often get released. Right, so they make a legal claim, they get released. It takes a year to hear, then they come back in, and this absurd merry-go-round just continues. In the case of Yaqub Ahmed, it continued for 8 years. Okay, well, we're 2 minutes past 1, which is almost exactly on time, so thank you very much for coming today.